Thanks, everybody, for being on the call. This was a really exciting development from the New Jersey Supreme Court, something we were all watching and waiting for with eager anticipation, and the two just best people possible involved on behalf of New Jersey Civil Justice. To have them both on the call to discuss the case is a great and wonderful thing. First, we have Gavin Rooney. Gavin is the chair of the Class Action Litigation Group at Lowenstein Sandler. He specializes in class actions and complex commercial litigation. He has argued numerous jury and non-jury cases across the United States, in state appellate courts, and before several circuit courts of appeal. And in addition to his mass tort work and general class action practice, he has, of course, been deeply involved in TCCWNA class action defense, both representing individual parties themselves and also, and maybe I would say most importantly from the perspective of New Jersey Civil Justice Institute, has been doing fantastic work on behalf of New Jersey Civil Justice Institute as amicus in numerous TCCWNA cases. He authored the New Jersey Civil Justice brief in the Dugan TJI Fridays case that we're discussing today, as well as our briefs to the New Jersey Supreme Court addressing the certified questions from the Third Circuit, which we will get to later in our call, as well as our briefs in other TCCWNA amicus briefs at the Appellate Division. So thank you, Gavin. Jeff Jacobson is a partner at Kelley, Drye. He's the former director of the New Jersey Division of Law and the former chief counsel to the New Jersey Attorney General. Now back in private practice, Jeff has also successfully defended a wide variety of class actions, including also numerous TCCWNA class actions. And again, most importantly, from the perspective of the New Jersey Civil Justice Institute, Jeff argued on behalf of our organization at the TGI Friday oral argument at the New Jersey Supreme Court because a scheduling change had precluded Gavin participating, and did a fantastic job and made really the very cogent arguments that were arguably embraced by the New Jersey Supreme Court in the decisions that we're going to be discussing today. So I want to thank Gavin and Jeff for their work on behalf of the organization. I want to say, just for anyone who's listening, that their thoughtful analysis and advocacy to the courts has really improved the understanding of this law to the benefit of the business community as a whole, and we appreciate their work. And I am now going to turn it over to Gavin to begin with a bit of an introduction and background on the Dugan case. Gavin?
Okay. Well, thanks everybody for joining us today. I'm here with Jeff. We're physically together. We're here to talk about a recent opinion that came out from the New Jersey Supreme Court in two consolidated appeals, Dugan versus TGI Fridays and Bozzi versus Carrabba's Italian Grill Restaurants. This is a significant opinion in the world of class actions, consumer fraud claims, and in particular claims under the Truth in Contract Consumer Notice and Warranty Act, affectionately called TCCWNA, which I think is probably the world's ugliest acronym. And it's an important opinion in that area because it's really the first time the court has spoken on these topics on the class action or consumer fraud side in probably about 7 years. And it's, I think, only the second time the court has spoken to the issue of TCCWNA and the elements of a TCCWNA claim. We'll talk about all three areas here today, but the focus of our discussions will be on TCCWNA. Just by way of introduction, to put this opinion into some larger context, as is, I think, widely known, over the past 4 to 5 years, there's been a spate of TCCWNA class actions that have been filed in the state and federal courts of New Jersey. They typically follow a similar fact pattern. I think of them as a game of gotcha, where a creative plaintiff's lawyer looks over a standard form contract or notice, finds a provision that the lawyer says violates a clearly established right of a consumer and therefore runs afoul of Section 15 of TCCWNA, or in the alternative, contains language such as void where prohibited by law, and then the plaintiff alleges that the contract violates Section 16 of TCCWNA, which generally requires companies to disclose whether certain provisions are or not enforceable in New Jersey if they have that sort of qualification. And then they bring a class action lawsuit, and they allege that every consumer that was subject to the offending notice or contract is entitled to recover a statutory civil penalty of at least $100 or class member. And whether these cases work or not on a class basis is a very important issue, and that's what the Supreme Court recently looked at in the context of the Dugan and Boese cases. I should pause and note also that the TCCWNA class actions, while, as I said, there's been a spate over them in the past 4 or 5 years, they really took off in 2015 with dozens of lawsuits filed, mostly in federal court, involving website terms of use, where a plaintiff's lawyer claimed that a term of use document posted on a website that was viewed or seen by consumers in New Jersey ran afoul of the statute and therefore entitled every consumer who bought product or services or visited that website to the $100 civil penalty. So with that background, in context, let's talk about the cases in particular and then go through some of the more important holdings of the cases. First of all, let's give a little bit of factual background to the matters. The two consolidated appeals share a somewhat similar factual background. They're both putative class actions against chains of restaurants alleging wrongdoing in the context of pricing issues. In the Dugan case, the theory of the case is that the defendant violated a provision of the Consumer Fraud Act, Section 56:8-2 in the NJSA, that requires a vendor to plainly mark on its stamp, label, or signage the price of merchandise offered for sale to the consumer. The Dugan plaintiff alleged that TGI Fridays violated this provision because in its drink menus that were handed out to restaurant patrons, it did not list in those drink menus what the price was for a beer or cocktail or other sort of alcoholic beverage, and alleged that that was a violation of the statute. The plaintiff brought claims under the Consumer Fraud Act as well as under the TCCWNA statute, and the TCCWNA theory, of course, was that by failing to list the drink prices, Section 15 of the statute had been violated, since that's, as codified in the statute, a clearly established right. The Boese case proceeded on a somewhat similar factual theory, relying upon the same statute that required the plain marking of pricing, but it had a little bit of a different twist. And there, the different twist is that they alleged that the defendant engaged in stealth price adjustments. In other words, if you sat down at a table and you ordered your first beer, you would pay $3.25 for that beer. But then if you ordered a second, the price would change between the first and second beer, and it would be $1 more expensive at $4.25. But again, it rested upon the same underlying alleged statutory violation of not listing the pricing for the drinks. At the trial court level, both cases were certified as class actions under the Consumer Fraud Act, or CFA, and under TCCWNA as well. Appeals were taken on an interlocutory basis from both trial court decisions. The appellate division took the Dugan case and issued a written published opinion reversing the order of classification. In the Boese case, by contrast, the appellate court did not grant interlocutory review and denied that motion. However, the defendant filed a petition for certification. After that happened to the New Jersey Supreme Court, there were also petitions for certification to the appellate division decision in Dugan that were filed with the High Court. Both were granted by the High Court, and the cases were consolidated for purposes of appeal. I should also pause and note that on behalf of the New Jersey Civil Justice Institute, once it got to the Supreme Court level, we filed an amicus brief focused on the TCCWNA issue. I took the laboring oar in drafting the brief. Jeff, who's with me here today and will be speaking as well, took the laboring oar in arguing the appeal to the High Court earlier this year.
Yeah, I mean, this is Jeff. I would just add that it was odd in this case that it's not odd that the plaintiffs didn't want to talk about TCCWNA in their briefing to the Supreme Court, because they didn't want to focus on just how big the case could be if you were getting $100 in damages for everyone who walked through the door of a TGI Fridays or a Carrabba's. What was a little odd was that the defendant didn't talk about TCCWNA either in the briefing, and so really but for civil justices having filed an amicus brief in this matter, the decision that we're going to talk about in the TCCWNA may not have happened, and the decision might have come out quite differently.
Thanks, Jeff, and that's certainly a great point. The focus of our argument on the amicus brief, which was also in the published opinion from the appellate division in Dugan, really focused on whether it could be said that each class member was a, quote, aggrieved consumer, which is under Section 17 of the statute, a predicate to having a private right of action to seek the $100 civil penalty, whether one could be an aggrieved consumer unless it was established in the record that each and every class member had, in fact, received a menu that omitted the drink prices. And that was really the focus of our argument, as we'll talk about in a few minutes, the focus of Judge Patterson's majority opinion. It was a 6-1 majority opinion written by Justice Patterson with Justice Albin in dissent. 5-1. Oh, we had one recusal. I'm sorry, 5-1. And there were two areas apart from TCCWNA that I think are worth mentioning, and I want to take a couple minutes on those and then spend the balance of our discussion addressing the TCCWNA claim. The first thing that I think was really important about the decision is it provided more definition about the standards for class certification, especially with respect to the factual record that a plaintiff needs to show in order to justify the certification of a class. And I think that's going to have some long-term impact on the lower court class certification. Plaintiffs up till now have liked to look at the Lee versus Carter-Reed case from the Supreme Court, which was, I think, the last time the High Court addressed the standards for class certification, and essentially tell trial courts, well, you have to take our theory at face value, and it doesn't necessarily matter what the record says about the facts. And what the new opinion does is dial back, I think, the implications of Lee versus Carter-Reed, because it requires the court to really look hard at what the factual record is to see whether common issues predominate or not. So, for example, in the opinion, Justice Patterson points out that the predominance element is a demanding element and far more demanding than simply asking the more general question of whether there are common issues that exist as opposed to whether they predominate. And importantly, she also held that the defendant's conduct alone, which is usually common in all of these class action cases, doesn't obviate the need for a searching inquiry into each plaintiff's particular response to that identical conduct. And I think that's a very important language. It's going to be important for the TCCWNA claims that we're going to talk about here today, but I think it's going to have broader impact on other motions for class certification involving claims under the Consumer Fraud Act and otherwise. And she paused and mentioned that while it's true that the court needs to look at the facts in a light favorable to the plaintiff on a motion for class certification, the court is under no obligation to simply accept the plaintiff's characterization that the case is appropriate for class treatment. The court instead needs to do a vigorous analysis to determine whether the elements of class certification are established by facts of record. So with that said, on class certification, let me just pause for a couple minutes about the consumer fraud claims that were examined by the court. And there the court came to differing conclusions in the Dugan and Bozzi cases based upon the different fact patterns that I mentioned before. In the Dugan matter, the plaintiff proceeded on a theory of ascertainable loss, and you recall that to have a private cause of action under the Consumer Fraud Act, the plaintiff needs to plead and prove and establish ascertainable loss in order to have a claim. The plaintiff proceeded on a theory of excessive pricing as a theory of ascertainable loss. And they were able to point to an internal study that the defendant, TGI Fridays, had prepared that essentially found that if they did not disclose prices, and drink prices in particular, they were able to charge more for drinks, and they were able to sell more drinks because you would not have a consuming audience that was price aware. And they actually, I think, calculated what the price difference was between the average table that sat down for dinner who had the prices and the average table of patrons that sat down for dinner that did not have the prices. And I think it worked out to a couple dollars per dinner. And the plaintiff rested on that internal TGI Friday study to say, aha, there's the ascertainable loss that occurred and was suffered by class members as a result of failing to list drink prices in violation of the statutory requirement that I mentioned earlier. The court rejected that theory and declined to certify that class, really holding that there had already been a series of earlier cases from the Supreme Court and the Appellate Division that declined to recognize price inflation theories of ascertainable loss under the Consumer Fraud Act. That line of cases started with the ISTAT decision about 20 years ago, which was an attempt to import the fraud on the market theory of the federal securities laws into the common law of fraud, where it was alleged that as a result of false statements released generally, a company was able to inflate the price of its stock. On a common law fraud analysis, the Supreme Court of the state declined to adopt the fraud on the market theory as a matter of common law in New Jersey. The court then took that holding about fraud on the market and, in a case called International Union versus Merck, extended it to the consumer fraud context, where it was alleged that Merck, by not disclosing certain adverse side effects, including the danger of heart attacks for its painkiller Vioxx, was able to inflate the price of the drug. The court held that that theory did not meet the standard for ascertainable loss under the Consumer Fraud Act. And likewise, in the case called New Jersey Citizen Action versus Shearing Plow, the Appellate Division had also found that claims of false advertising with respect to the prescription antihistamine Claritin was not, you couldn't create ascertainable loss by saying that as a result of the false advertising, Shearing Plow was able to raise the price for its drug. In each of these cases, the court essentially held that there's nothing like an efficient market for consumer goods, that you could therefore claim that releasing false information to the consuming market allowed the defendant to increase its prices, that you had to show more particular damage incurred by class members as opposed to a blanket allegation that as a result of the wrongful conduct, the defendant was able to increase its prices. So that led Justice Patterson to her conclusion that the class did not work on the CFA claims for Dugan. However, she reached a different result on the CFA claims in Bozzi because of the difference in the factual theory. There, recall, it was the difference in price between beers 1 and 2, where the price went up by $1 during the same meal at the restaurant, and that price increase was not disclosed to the consumer. There, the court held that that's not a price inflation theory. That's simply charging more when you don't really seem to have a reasonable or logical basis to do so, and where there's a statute on point that, at least as the plaintiff articulates it, requires the disclosure of the price, including presumably the disclosure of the increased price when you raise the price between beers 1 and 2. So the court on that claim, which did not involve a more traditional price inflation theory, found that the damage could be proven by receipts, and receipts held by class members, and presumably receipts or computer records held by the restaurant chain as well, and found that that case should be certified for class treatment. So with that said, let me move on from the consumer fraud claims to really the meat of what we're here to talk about today, the TCCWNA claims. There are two aspects to the TCCWNA analysis in Justice Patterson's opinion. The first deals with the aggrieved consumer element, which I'll address for a few minutes here. And then there's a separate discussion that addresses the clearly established element of Section 15, which Jeff will address in a few minutes. Let me start with aggrieved consumer. On the question of class certification, I've always thought that what it means to be an aggrieved consumer is really where the game is in terms of being able to either certify or defeat certification of a TCCWNA class. The plaintiff's theory of class certification in these TCCWNA claims is usually that so long as they find a standard form contractor notice, and they can find within that contractor notice a provision which they say violates someone's rights in violation of the statute, and every class member signed, was exposed to, was subject to in some way, shape, or form that standard form notice, and that's all they need, and they can have a class certified. Now, of course, to have standing to sue under the statute, you need to be an aggrieved consumer, and to get the class certified, presumably, you'd have to be able to establish aggrievement on a class-wide basis. And that's really what the court's opinion here started to dig into. What does it mean to be aggrieved? And when you think about the fact patterns of what it might mean to be aggrieved, you can look at different layers of the onion. I think the first layer, and the one the court directly addressed in this opinion, was is there evidence in the record that every class member was in fact presented with or exposed to the contractor notice with the offending language? The second layer of the onion is whether the class members actually read the document or notice that had the offending language. And then I think the third layer of the onion is, did that offending language or notice that was not only presented to and read by the class member have some sort of adverse impact or effect or create some sort of injury on the part of the class member? And I think those are the three layers of analysis one could put into the definition of aggrieved. On this opinion, the court really just directly addressed the first issue, and addressed the first issue because the defense raised was that while it may have been desired by the company, by the restaurant chain, to present drink menus to all patrons, that didn't always happen, and many times did not happen. And therefore, if a class member did not receive, when they sat down for a meal at TGI Fridays, a copy of the drink menu that omitted the prices, and just ordered a beer because they felt like a beer that day, that person could not possibly have been aggrieved. The plaintiff's response to that was to point to training materials and policy-level materials that said what you would normally expect them to say when they train their wait staff. You're supposed to hand out menus, including drink menus. And the plaintiff tried to rely upon that as evidence that all class members, everybody who had gone to buy these drinks at a TGI Fridays, had in fact been exposed to the menus without drink prices. Importantly, and this echoes back to the language about the standards for class certification in terms of review of a factual record that I mentioned a few minutes ago, the majority opinion held that simply pointing to the training materials was not enough to show the critical nature of the interaction between every class member and the offending menu. The court found that level of proof from the plaintiff, who bears the burden of proof on class certification, was not sufficient, because unless a class member had actually received the menu and been presented with the menu that that omitted the drink prices, you wouldn't have a claim. That person wouldn't have a claim under TCCWNA. On three separate occasions, Justice Patterson's opinion talks about the critical inquiry or the critical interaction between the consumer and the document that contained or omitted the offending language. And the court concluded that since there was no sufficient evidence to conclude that all class members had in fact been exposed to it, that the class should not be certified. So, one of our questions and issues rising out of Dugan is how far can we push it? Because Dugan did involve a factual situation where it was true that not everyone was exposed to the contractor notice with the offending language. What does that really mean going forward? What does that mean in situations where the class is defined as people who all signed, and obviously if they signed it, they must have been presented with it. All class members had signed the same form contract. There are many such TCCWNA class actions out there against various service providers and retailers that use standard form contracts.
And just as importantly, if you, for example, agreed to terms of service but would have needed to click on a separate link in order to see the terms of service, are you aggrieved if you can't prove that you actually clicked on the link and read the terms of service before you accepted them?
Yeah, I think that online terms of use, at least when it's a browse wrap, where there's no requirement that the consumer actually clicked on the link, and we all know 99.9% of people will not click on that link. I think only lawyers do that are interested in these issues. I think that those sorts of classes would lack standing and lack the ability to get certified under Dugan. But a related question is, what do we do with where do we go with the cases where they're defined by classes that all sign the same common form contract? That issue, I think, is left a bit open by this opinion, but I do find help and comfort in the language that Justice Patterson used in her opinion. As I said before, she did speak about the critical interaction between the customer and the document on 3 separate occasions over, I think, 3 pages of the opinion. And that indicates that it's not enough to just have been handed a document that you never looked at and read. If it's that critical that you interact with it, presumably you must have had to read it. And in addition, when she actually reached her holding, she said that presentation of the document was what was required at a minimum. And on page 63 of the slip opinion, she held that a claimant who does not, at a minimum, prove that he or she received the menu cannot satisfy the elements of TCCWNA and is not an aggrieved consumer.
And that was, by the way, she was picking up on an argument that we made, which is we basically showed her several places where you could draw the line. And she drew the line where she basically said that this is the only line we need to reach to reach the decision in this opinion, that if you weren't presented with the menu, that's not enough. But she was leaving open the possibility that it was necessary but not sufficient.
So when I read her at a minimum language, what I read that to mean is, well, aggrieved requires that you receive the document, you were presented with the document, but it's not defined by that. It could mean more than that, and probably does mean more than that. But I think it's also fair to say that the court probably left for a future day to define what more is actually required. And as we'll talk about in a minute, that issue may come up relatively shortly. But that's my overview of the aggrieved consumer part of the opinion. And just circling back to what I started with, I think a good, sharp definition of aggrieved consumer, if there is a magic bullet to get rid of or solve the issue of TCCWNA class actions, it's a definition of aggrieved consumer that makes it difficult to litigate on a class-wide basis. And if we can get to go there, that will be the solution to this issue. But let me turn it over to Jeff now to speak about the clearly established issue.
Sure. So Gavin is exactly right that aggrieved consumer is the critical inquiry at the class certification stage. Ideally, though, these cases would never be brought, or if they are brought, there is a means of getting rid of them at the pleading stage, which is where the clearly established part comes in. But before I talk about what a good thing this decision is, and it is an excellent decision, I want to talk first about what it's not. So, as Gavin mentioned, the TCCWNA has 2 operative sections. The first, Section 15, says you can't have a provision in a contract that violates a clearly established legal right. And the second basically says if you have a provision in the contract that violates a clearly established legal right, you can't weasel out of it by having another provision saying some of this might not apply to you if you're, this might not apply in all states. So it has a flat prohibition against those kinds of some states don't do this exception. And if you have one of those exceptions and don't explain exactly what is ineffective in New Jersey, you violate Section 16. I should note that TCCWNA is the only statute of its kind in the country. There was a decision holding that something similar could conceivably be argued under California statutory law, but the only state that does this explicitly this way is New Jersey. And the spate of TCCWNA class actions that were filed over the past couple of years caused many of us in the profession to be advising all of our clients a little bit with our hair on fire to scrub their online terms of service and their other contractual documents. There are some easy fixes you can make to these documents to largely insulate them from TCCWNA liability. And notwithstanding this opinion, those kinds of changes are still a very good idea for several reasons. One, the Dugan-Bozzi opinion did not address Section 16 at all. So if you are in a Section 16 situation where you have a some states exclusion, this opinion it leaves Section 16 completely open to interpretation of what it does and does not mean. Second, it is possible to imagine a set of circumstances, and Gavin was alluding to it a little bit in his discussion of aggrieved consumer, where you are in an industry that is subject to a statute that is clear on its face, or a published Supreme Court opinion, or even a published appellate division saying that you can't waive this liability or you can't do something that you're doing, and where, as Gavin said, all of your customers have to sign a contract. If everybody signs a contract, and if the contract contains a provision that violates what we'll talk about in a second as a clearly established law, this opinion is of some use to you, but is not as useful to you as it might be in other contexts. And the court was asked to go further and basically hold that TCCWNA should not be a class action statute, and they didn't like that argument. They gave it short shrift and a footnote. And so this is not a case that kills class actions completely dead in the TCCWNA context. It leaves open the possibility of certification in different circumstances. So why is the clearly established provision so important here? It's important because what the court said in this case is that, well, wait a minute. Yes, there is that provision of the Consumer Fraud Act that very clearly tells, for example, supermarkets that they have to post prices on the shelves. No one, however, had ever articulated prior to this case that provision applied in the restaurant context at all, much less to drinks where there can be as many drinks as the bartender's imagination. So, for example, even if you had a menu that had beer prices on it, is that printed menu necessarily going to have the price of every beer you might have on tap that night? If you have a menu that says that a scotch is $10, do you have a price for a double? And so the court was troubled a little bit by the idea that this statute does not necessarily lend itself to being applied in the restaurant context. And the question came up at the hearing, and it came up in the briefing, has anybody ever applied this to restaurants before? And the plaintiff's honest answer was no. The Attorney General has never enforced in this area, at least not publicly. There was no decision prior to the decision in this case holding that it's even arguably a CFA violation. And what Justice Patterson said in this case is, for clearly established to mean anything, it has to mean that there is some piece of paper that a reasonable person in this industry can look at and say, yep, I got to do that. And whether she did not explain exactly what it means, but she explains what it didn't mean. And it didn't mean the decision in this case to be the first one to find that a provision that does not on its face apply to restaurants is going to subject a restaurant to a $100 a head set of damages. So this decision left open what clearly established requires. She talks about a published opinion, so I think it would now be a little dangerous to not be checking out certainly Supreme Court opinions and at least published aptive decisions to see if they opine in your industry that a liability waiver, which is the subject of a lot of TCCWNA class actions, or some consumer fraud interpretation affects you. Because once there is a decision that affects you, if you are not conforming your behavior to that decision, arguably there is a TCCWNA problem that would at least survive a motion to dismiss, and then you've got to think about the aggrievedness of it and worry about what you're going to do at the class certification stage. But what I found so interesting about the clearly established part of the decision is, after the court reached its decision on aggrieved consumer, it didn't really need to do what it did. It didn't really need to get as far as it did on clearly established, because they had done enough on aggrieved consumer to blow out the class certification decision that was really at issue here. And this was, as Gavin mentioned, this case reached the Supreme Court in the posture of an interlocutory appeal from a class certification decision. This was not a merits session, basically, and nevertheless, the majority of the court reached very far to say, hold the phone, TCCWNA requires the clearly established legal right, and clearly established has to mean so. And so they cast some real aspersions on the merits of this claim at the class certification stage, saying this just isn't clear enough. And if you have the occasion to read Justice Albin's dissent, and it is as Justice Albin's dissents always are, cogent and a very clear articulation of his view of the law, what Justice Albin said is, look, I think it's perfectly clear that this statute applies to restaurants. A price is a price is a price. And on that basis, he disagreed with the majority's TCCWNA opinion. But that's what you need to say in order to find that a case like this would involve a clearly established legal right. You have to say, look, it looks clear to me. And you would be subject to a little bit of judicial whimsy, because if you're in a world where a judge is able to say, well, it looks clear enough to me, and it's not what a more objective observer would determine to be clearly established, then TCCWNA could still mean almost anything. It could mean whatever a particular New Jersey judge says it means. So the lesson that I would take away from this is keep monitoring your terms of service, keep monitoring your customer form contracts, keep monitoring what you're doing to make sure that your clients and you are conforming your behavior to the latest interpretations of the Consumer Fraud Act and the law against discrimination, because once there is a decision out there, your risk under the TCCWNA increases if you are not conforming your behavior to that decision. But this opinion went out of its way to give TCCWNA defendants an argument at the motion to dismiss stage that unless there is a reasonable observer clearly established, I'm making up reasonable observer, that's not in the opinion, but unless there is a fairly objective definition of clearly established, and unless you can look at it and say, yup, that's clearly established, these TCCWNA cases should go out on the dismissal stage, and we have to worry about aggrieved consumer and whether or not we're going to be able to slice and dice among the class members, although that is something that Gavin and I both do for a living.
I mean, where I would like to see the court ultimately go and clearly established is to adopt the standard that basically says any reasonable merchant, not even a lawyer, but any reasonable merchant would know better than to put this into a document.
Which, by the way, is what one of the federal judges who heard a case prior to the Supreme Court having heard this case, exactly what that judge opined. I quoted that argument to the Supreme Court. They didn't adopt it wholesale, but it certainly seemed to have been in their minds. Now, should I talk about Wenger and Spade, or is that on your agenda?
You can talk about that, but let me just interject with one other thought before we leave the Dugan opinion and talk about the opinions that are coming up. It bears mentioning, I think, and it's certainly in the opinion, but it was a very significant discussion at oral argument, that the nature of the damages here on the $100 civil penalty amounted to $1 billion, literally. And Jeff will remember this well. He was there. I watched it through the podcast. There was a question posed by one of the justices to the plaintiff's attorney.
Oh, it was Justice Patterson. She was very, very attuned at that point to the $1 billion.
And she walked the plaintiff's lawyer through the math, and she said, well, you say there were X number of patrons in your class that went in and ordered drinks whose rights were violated under TCCWNA, and it's your contention that they're owed $100 apiece for each visit to a TCCJI Fridays, right? Right. So in other words, what you're asking for is $1 billion judgment. And the plaintiff's lawyer looked right at her and said, that's correct. And, you know, there are sometimes moments during oral arguments where you feel like the issue finally got crystallized in the right way, and there's a moment where it turns. And when I watched the argument, that was that moment. And it is mentioned in the opinion. Now, I'll pause and note that, you know, you're talking in this case about a $2 beer and a $100 civil penalty with a pretty obvious and gross disparity. And that's not always true in other factual circumstances. But I think it is troubling to the courts that if these TCCWNA class actions really work, that New Jersey businesses can face crippling judgment.
And not just New Jersey businesses, but national retailers that do business in New Jersey.
Businesses, I should say, businesses doing, companies doing business in our state. That's right. Jeff, you want to talk about
Sure. So as Gavin mentioned, the TCCWNA had been a sort of sleepy world that the Supreme Court had not opined on in quite a while. But in rapid fire, by virtue of all of these cases percolating up to the federal courts, although because of the Class Action Fairness Act, although some were in state court as well, they were getting a lot of activity at once. So there were 3 federal cases, the Crosskill case, the Wenger case, and the Spade case. I won't bore you with all the details, that 3 different district judges made varying decisions that reached the Third Circuit at about the same time. And the Third Circuit was suddenly realizing, wait a minute, we don't really know what aggrieved consumer means, and wait a minute, we don't really know what clearly established legal right means. And they certified in 2 of the cases, the Wenger and the Spade cases, they certified essentially those questions to the Supreme Court. One is basically, what does aggrieved consumer mean? And the other is a bare violation of a disclosure provision of the Consumer Fraud Act enough to satisfy the clearly established legal right provision. So right before the argument in Dugan, but after they accepted review in Dugan and Bozzi, the Supreme Court accepted those certified questions. They had not gotten any briefing on it yet. They had any new briefing. They had just gotten the certified questions and the questions as they were presented to the Third Circuit. So at the time that we were arguing this case, they had accepted Wenger and Spade. They knew that they had to deal with these issues sooner or later, and so they were perhaps attuned to knowing that they were going to have to address aggrieved consumer and clearly established legal right in due course, and maybe this was as good a time as any. But it looks like maybe they're not done, because there is a tentative argument date coming up for the Wenger and Spade certified questions in November. Whether that actually will go forward, we don't know at this point. It hasn't been taken off calendar yet, but whatever happens on that day, if it happens at all, is going to be speaking very clearly of Dugan and Bozzi. The entire oral argument is going to be about Dugan and Bozzi for sure. And after that, what will happen is the Third Circuit will then decide Wenger and Spade, and then a whole bunch of us that have cases stayed by other district judges pending the Third Circuit's decision in Wenger and Spade, which is awaiting the Supreme Court's decision in Wenger and Spade, will get going again. And those cases will either die on the vine or not, depending on what further the Supreme Court sees fit to do in the Wenger and Spade certified questions now that they've decided Dugan and Bozzi, and there's no going back. And I'm serenely confident that Justice Solomon returning to the bench is not going to change this outcome.
Yeah, I don't think so. I'll just supplement what Jeff said, that the tentative argument dates for Spade and Wenger are November 6 or 8. I don't think a particular date between those two has yet been selected. It was originally noticed for argument today, either yesterday or today, but that was adjourned until November. Suspicion is that the release of the Dugan opinion probably had something to do with putting off that argument, since obviously Dugan will have a lot to do with that argument.
And they've not asked for supplemental briefs as of this speaking.
Yeah, the question that the court will answer in the next case, Spade and Wenger, is whether a class member who has not suffered any adverse consequences of the noncompliance can be said to be aggrieved under TCCWNA. And I'll just note that on behalf of the Civil Justice Institute, we also submitted an amicus brief in that case arguing that the answer is no. Someone who hasn't suffered any adverse consequences is not aggrieved under TCCWNA. And aggrieved means not only that you were presented with the document, but you read it, you cared about it, and you suffered some sort of adverse consequence. You were misled, you didn't understand what your rights were, you were deceived as to your legal rights. The kind of injury or wrong that was the motivating factor, as we see from the legislative history behind TCCWNA.
And if they go that far, which was something that they did not have occasion to do in Dugan and Bozzi, but if they go so far as to say that you are not aggrieved unless you were dissuaded essentially from bringing a claim you thought you had by virtue of the language in the contract, then this law is dead.
Yeah. So we will watch with interest what the court does. The one other pending series of appeals that relate to this that bear watching are 4 TCCWNA class actions that are currently consolidated for appellate purposes before the appellate division right now. These are the Duke, Barbarino, Greenberg, and Walters matters. Each essentially involve a claim that the standard form contract used by New Jersey car dealers to lease or sell vehicles violates Section 16 of the statute. That's the section that Jeff had mentioned before that talks about geographic or jurisdictional differences in enforceability of contractual provisions. The court held argument in those consolidated appeals in the spring, and then Judge Sabatino said he was going to hold a decision on the appeals pending the outcome of Dugan, and we've just been asked to put in supplemental briefs on what Dugan means for those appeals. My guess will be he'll probably wait for Spade and Wenger to be decided too. But that case, its fact pattern really tees up what an aggrieved consumer is. In this case, it was language in fine print on the back of a standard form contract that 99.999% of the class never read or thought about, complete technicality. And that would probably provide a good factual mechanism or factual context in which to hold that a consumer is not aggrieved in those circumstances.